Yes, Mr. Brown.
My Lords, I will be addressing two brief points. Section 9 of the Arbitration Act and alleged abuse of process. Turning first to Section 9. My learned friends say in paragraph 201 of their written case that if RCA wished to contend that the English courts cannot hear this claim, then it was required to seek a stay under Section 9 of the Arbitration Act. That isn't right. Section 9 simply does not arise in the present case. Section 9 itself is on page 923 of the bundles, and Section 9 sub 1 provides that a party to an arbitration agreement against whom legal proceedings are brought in respect of a matter which under the agreement is to be referred to arbitration may apply to the court for a stay. If, as we say on this side of the court, the English court does not have jurisdiction in this case, then these proceedings will come to an end. If permission to serve out is not given, then the English court has no jurisdiction at all, and there will be no need for a stay under Section 9. On the other hand, if your lordships are against us, and it's held that the English court has jurisdiction, then necessarily the court will have found that this claim, i.e. the claim for breach of the arbitration agreement, is not a matter that needs to be referred to arbitration. And so Section 9 won't apply. So in short, the question here is whether the English court has jurisdiction at all. And the answer to that question will determine whether these proceedings should continue or not. An application for a stay under Section 9 would add nothing to that analysis. And there's a further point, which is that there would or might also have been a risk that in making a Section 9 stay application, it could have been said that RCA submitted to the English jurisdiction. And given that there was simply no point in making a Section 9 application, there was no reason for RCA to take that risk. And the only case that my learned friends have cited for the proposition that RCA should have applied for a stay if it wished to argue that the proper place to bring this claim was before an arbitral tribunal in France is Norrie Holding. And the relevant passage is on page 1738. This is in the judgment of Mr. Justice Males, as he then was. And he held in paragraph 41 that where there has been no application for a stay under Section 9, there is no reason why the court should not exercise the jurisdiction to grant anti-suit relief, which it undoubtedly has. But the key point here is that in that case, the English court had jurisdiction because there was a London-seated arbitration, and so service out was permitted under the arbitration gateway CPR 62.5 without the need for permission. Mr. Justice Males was therefore concerned solely with whether to exercise his discretion to order an anti-suit injunction under Section 37 of the Senior Courts Act. And that's the context in which he noted the similarities, the other side of the coin, that Section 9 stay and an anti-suit injunction represent. So Norrie Holding is of no assistance to my learned friends on this point. It is only authority for the proposition that if you are properly before the English court but want to resist an anti-suit injunction on the footing that an application should be made to the tribunal, you should apply to the court for a Section 9 stay to that effect. But that is simply not this case. So ultimately, the Section 9 stay point is a red herring. we were not required to apply for one in circumstances where the court's decision on the logically prior point of jurisdiction will determine whether these proceedings are to continue or not. If I may turn to my second point, alleged abuse of process. My learned friends rely on one sentence in paragraph 78 of the Court of Appeal's judgment and contend that it is an abuse of process for RCA to maintain contradictory positions in Russia and England, and that this forecloses RCA's arguments on proper place. And we've addressed this in paragraphs 138 and 139 of our written case. There are 2 points for me to make orally. The first is that RCA's position is not abusive. RCA is entitled to make arguments about the enforceability of the arbitration agreement. Indeed, that point is common ground. UniCredit has expressly accepted it. I could ask my lords to turn to the Court of Appeal order, page 856, or it's in the key documents bundle at tab 4. This is the Court of Appeal order that we are appealing against. And on the second page, page 856, the second undertaking there reads as follows. And upon the appellant, UniCredit, undertaking not to contend in future that the effect of the relief granted herein, or any findings made or necessarily implicit in the grant of such relief, precludes any position which the respondent, RCA, may adopt as to the non-existence or scope of arbitral jurisdiction, including questions of arbitrality and public policy, or breach of any of the arbitration agreements before any arbitral tribunal, or, so far as admissible, any competent court in France as the seat of any future arbitral proceedings. UniCredit gave that undertaking because it accepted that RCA cannot be precluded from making arguments about the scope or enforceability of the arbitration agreements before an arbitral tribunal or the curial court in France. And they explained this point in their reply skeleton. I could ask you to turn to page 466 of the bundle. The bottom of the page, paragraph 30, is addressing final ASI relief and why they say it should have been granted. And over the page, page 467, subparagraph B, they draw in that paragraph a distinction between an interim and a final anti-suit injunction, and they point out the risk of preclusion arising from the grant of final ASI relief. So in other words, RCA should not be precluded from making arguments about the enforceability of the arbitration agreements before this matter has come before an arbitral tribunal. And they recognised that the risk of preclusion is a potential injustice to RCA, and that the way they proposed to deal with that was to give the undertaking that I've just gone to.
That is the 8th recital that they're
That's
referring.
exactly, that became the second recital on the page that I showed my lords. So UniCredit has expressly accepted...
What are you not being precluded from doing then?
As it says in the recital, my lady, we're not being precluded, UniCredit, I should say, sorry, is undertaking not to contend in future that the effect of the relief, the effect of the final ASI is granted, precludes RCA from making any arguments about non-existence or scope
Before the tribunal in France.
before the tribunal or before the imperial court.
Anywhere, yeah.
Yes. So they accepted that we should be entitled to do that. Before this matter has come before a tribunal, such matters cannot be resolved. We should not be precluded from making arguments on those matters. And in those circumstances, there is nothing inconsistent, let alone abusive, in RCA saying, one, that the proper forum for UniCredit's claim is arbitration, as we've been submitting, and that two, RCA remains entitled to contest the enforceability of the arbitration agreements. That's an entirely legitimate, consistent position for RCA to adopt. And my learned friends have referred to what RCA has said to the Russian courts back in August of last year, but that does not take the argument any further. RCA is entitled to make arguments about the enforceability of the arbitration agreements. That's accepted. And it did so in the statement of claim in the Russian proceedings. But arbitration remains the proper available forum for UniCredit's claim. Yeah. My second point on this is a shorter and more fundamental one, set out in paragraph 139 of our written case, and it's this: allegations of inconsistency or abuse of process form no part of the jurisdictional analysis. That is just not how CPR Part 6 and the relevant authorities work. My leader, Mr. Gunning, has gone through those matters in some detail, the questions that your lordships have to ask, and the arguments that we make on those questions as to proper place. My learned friends say that if RCA has been inconsistent or abusive, then it is foreclosed from making arguments on proper forum. That's the word they use in paragraph 202 of their written case. But they cite no authority in support of that assertion, and it is just wrong. UniCredit has the burden here to show that England is the proper place for this claim. Even if RCA had been inconsistent, which, as I've said, it hasn't been, but even if it had, then that does not automatically make England the proper place. And nor does it prevent or preclude RCA from making arguments on jurisdiction as we have.
So where does abuse of process arguments, where do they come in to the general picture in that case?
I would accept, my lord, it comes in at the section 37 discretion stage.
Right.
So where the English court has jurisdiction and it's deciding whether to grant an anti-suit injunction, what relief to grant. At section 37 stage, I readily accept the court can take into account all the circumstances, and allegations of inconsistency, abuse of process could be part of that analysis. Yes. But on jurisdiction, there is a framework as to the questions that have to be asked and what has to be established, that England is the proper place. And the suggestion that the alleged inconsistency of one party could somehow make England the proper place is simply not a good point. So, for the reasons I've set out, the alleged abuse argument is both wrong and legally irrelevant. My lords, those are our submissions, unless I can be of any further assistance.
Thank you very much, Mr. Brown.
Thank you.
Now, does that complete your submissions, Mr. Gunning?
I'm sorry, yes.
No, I'm just checking. That's fine. Thank you very much. Mr. Houseman.
Yes, good afternoon, my lady, my lords, and happy birthday to one of you, as I understand it.
What better way could there be of spending one's birthday?
I appear together with Professor Jonathan Harris and Mr. Cribb. Mr. Harris joins our team, if I can refer to the postscript of Lord Gough in the Spiliada, as a further pilgrim on the endless road to unattainable perfection. But I can vouch for the fact that some of our conversations have been very interesting. Mr. Cribb will take care of one or two procedural points, either at or towards the back end of my slot, as it were, tomorrow. I anticipate that today, once I've done some opening general responsive remarks, I will cover the applicable law gateway point, but probably not get to forum until tomorrow morning, but we're still in good time on that. I may yet, and I may say some things which foreshadow what I will say on forum. Can I just start by asking this court to take a step back and ask itself, why are we in the English court, we, my client? It is to seek a remedy to stop unlawful pursuit of Russian proceedings. In other words, this whole claim, this whole action, and therefore this appeal, which is purely jurisdictional, is about stopping the Russian proceedings. Why does my client want to do that? Let's leave aside the niceties of issue estoppel, res judicata, and conflicting judgments. It needs to stop that happening because it's about to have judgment entered against it for 450 million euros plus some more in interest. And that is going to happen in the very near future if RCA is not enjoined. The Court of Appeal saw the sense of that, and as well as allowing the jurisdictional appeal, granted the final mandatory remedy on the day, recognising the urgency of that situation, and refused to stay or suspend that remedy twice, because twice they were asked to do so.
Can I kind of intervene, just to indicate, as I understand it, the Russian proceedings have currently been stayed by the Russian judge until the 6th of May. I think that's...
Yes, the next hearing is on.
I think that's the date.
We have to be careful how we view that use of the word stay. The way the process works in the Russian court and similar court systems is there's just a series of adjournments of the hearing, where it goes from one to the next. At any point in time and in any one of those hearings, the court can just give judgment.
Yes, so the next hearing is on the 6th of May.
Yes, I understand.
So it would be very helpful to both parties, I imagine, if this court is in a position to give a decision sometime next week.
We would ask that, yes.
Yeah.
And the Court of Appeal, like I say, saw the practical risks and the imminent risks faced by my client of a substantial and final monetary judgment being entered by the Russian court in circumstances when my client has executable assets in the jurisdiction. And that is why, if I may say so, my client has not bothered with what would be the futile step of arbitration in Paris to seek one of those arbitral orders that achieves nothing, and has come to the English court to get a final mandatory remedy, because that's the only thing that stops unlawful foreign proceedings. That's why we're here.
And what reason is there to think that an order made by this court will have any effect in what the Russian court does?
Well, that's down to compliance, ultimately. If the mandatory positive injunction says you must take all necessary steps forthwith to withdraw your claim with prejudice, then they can either comply or not. If they choose not to comply with that order, they're going to put themselves on the wrong side of the English contempt regime, and something tells me that is a discipline upon them. Whether the Russian court itself chooses to heed that request for the withdrawal of the action is another matter, but the English court will exercise its discretion to grant injunctions, and in particular anti-suit injunctions, unless it can be shown that they would be brutum fulmen. And this is not a situation where there is any evidence of Russian law to suggest that the order would be brutum fulmen, point one. Point two, that all falls within ground 3 of the appeal in relation to final relief, in respect of which permission was refused. And I was, at that point, just going to lay out the groundwork for what was sought on permission to appeal. There were 4 grounds of appeal in the original permission application. Grounds 1A and 1B both related to gateway, the anchor point, but ground 1B was an appeal on the basis that anchor was wrongly decided, and permission was refused for that. And I did observe, for large parts of my learned friend's submissions in the middle part of this morning, that he seemed to be arguing that anchor was wrongly decided. The logic of his position was very much that you should rotate that hierarchy or cadence in anchor. But 1B is out of the question. The fight is over whether the Court of Appeal, in this case, erred in law in finding that...
Well, I think in anchor we applied the law of the seat, didn't we?
I'm sorry, my lord.
In anchor, didn't we find that it was the law of the seat that applied?
The majority did.
Yes, well, the court did, yes.
The majority found that there was no choice of law for the construction.
So it's hard to see how we'd be reversing that decision if we accepted his argument.
No, the guidance contained in anchor is universally understood as creating a cadence or sequence or hierarchy where chosen law has primacy. And choice of seat sits in underneath that when there's no choice of law. And all 5 justices on the panel in that case adopted that sequence, and we'll look at that in due course. But like I say, that's foreshadowing slightly. Going back to the grounds of appeal, ground 2 is forum. I accept we have the burden on that, but in a sense, my learned friend has the burden of showing that the Court of Appeal erred in law on that, and we say they did not. And then ground 3, which was the 4th distinct ground of appeal, was an attempt to appeal the Court of Appeal's exercise of its equitable remedial discretion to grant that final relief. And this court refused permission on that. And you'll have seen from section B of our written case that we set out those parts of the Court of Appeal's reasoning and their implications which are beyond the scope of this appeal. And indeed, my learned friend started this morning waving his banner about novelty. This is the first time such an injunction has been granted. But that's all part of equitable remedial discretion. All invocations and incantations of comity and respect for the feelings of the court of seat all go to whether it's appropriate in the circumstances of a given case to exercise that remedial power under section 37 of the 1981 Act. They don't go to the question of jurisdiction in personam. All the English court needs is jurisdiction in personam in order for it to have that section 37 power, and then you get into the highly contextual, highly circumstantial inquiry as to whether it's appropriate to exercise that power. That's what the Court of Appeal did, and subject to holding on to jurisdiction, that is beyond the scope of this appeal. So all those questions about comity, etc., are over the line. They're not part of the forum inquiry. Now, just clearing up some terminology points, when we are looking at ENCA and English private international laws to choice of law, obviously there are references in different schemes and different cases to either applicable law, governing law, proper law, or in the case of ENCA itself, the arbitration agreement law. They are all the same thing. They are all the law that governs, the system of law that governs the existence, validity, scope, effect of the arbitration agreement. Its waiver, its discharge, etc. The stuff we call contract law, colloquially speaking. There's also been various attempts to come up with a universal label for the contract in which you find the arbitration agreement. Matrix contract, host contract, main contract, again, all interchangeable. The Law Commission, I think, seems to favour matrix contract. We plumped for host contract in our written case, but I know that in the ENCA judgments, they go for main contracts, all the same thing. That's one terminological point I just wanted to clear up. There's also appearing throughout our written case an abbreviated reference to the relevant article in the Russian procedural code, the arbitrage procedural code, which we abbreviate to APC 248. Strictly speaking, it's 248.1 and 248.2. It caused a bit of confusion when the bundles were being prepared, because the original Article 248 was put in full, and it's actually not very informative. By way of quick historical update or background, the new Article 248.1 and 248.2 were enacted by the Russian legislature in the middle part of 2020 in response to international sanctions regimes flowing originally from 2014 following the invasion and annexation of Crimea. And you have in the bundle the original sanctions instrument from the EU Council. Article 248.1 and 248.2 allocate to the Russian Arbitrage Court exclusive jurisdiction and effectively override the party's choice of arbitration or litigation, choice of court abroad. We say, by deeming all such clauses to be inoperable where sanctions are involved, that is a violation of the Russian state's obligations under international law, because it removes from the Russian court's procedural armory its staying power pursuant to Article 2, Roman 3 of the New York Convention, the thing that we call Section 9, and which the French courts call Article 1448 of their civil code. And that is a violation of international law. You don't have to go that far, but my learned friend suggested that it wasn't, and it is. One final terminological clarification. Throughout our written case, we've referred to signatories of the New York Convention as if they're all the same, and I apologize for that. That's not strictly accurate. There are over 160 contracting states to the New York Convention, but only 20 or so are signatories. They include Russia and France. And take a step back, and you will see what we have said in Section B about comity, and that is what we are asking the English court to do here is simply supply a remedy that a signatory of the New York Convention, France, does not have in its procedural jurisdiction in order to achieve the very same outcome which another signatory of the New York Convention, Russia, ought to have achieved through granting a mandatory stay of this claim. That's all we are seeking. The remedy we seek upholds the scheme of the New York Convention, gives effect to the arbitration agreement, and forces any claim under these bonds into Paris arbitration. That's all. Now, in terms of the outline and scheme of my submissions, I was proposing to take you briefly through sections C and D to cover the Russian risk, but without delving into the evidence unduly, and also French law. And then, of course, sections E and F for gateway and forum. There is one last terminological point to pick up, however, and it's a very important one, and it's the concept of French law. We will look at in due course at what the Dalico principles are. In other words, the French lex fori principles of so-called international arbitration. And what you will see when we look at that is it is impossible to map those Dalico principles onto the exception in ENCA in the same way that it is impossible to map them onto the Scottish Section 6, the Swedish Section 48, or for that matter, the new English Section 6A when it takes statutory force. And the reason it's impossible to do so is because there is no such thing as French law applying French law. That is a fiction created by my learned friends, very ingeniously, through their written case, where they seek to turn a French rule of lex fori, effectively a French rule of private international law, from something which we describe as intransitive, because it doesn't apply another system of law, it doesn't actually do anything, it just gives you the answer to validity, existence, scope, etc., and turn it into something transitive. And every time my learned friends formulate that in writing, they supply verbs to make it transitive. So they say French law applies French law, is a phrase which appears throughout their written analysis, or they say according to French law governs. And they are making the Dalico principles into something they are not. And that is something I know that came up in the course of this morning with various questions from this court to my learned friend. But you have to be very careful to understand what the Dalico principles are. They are not doing that at all. They are just providing the answer to whether there is an arbitration agreement, whether it's enforceable, and what it means. Now, I just wanted to give emphasis to one or two points before going through that scheme of my submissions. The first one concerns the distinction between proper forum and equitable remedial discretion. I've touched on that already. My learned friend was clear at the beginning of his submissions that this is a laser-focused inquiry on jurisdiction. So the outcome of this appeal is the binary all or nothing question: does the English court have jurisdiction in personam over this defendant in respect of this claim? Full stop. All of the contextual and flexible inquiry as to whether it's appropriate to injunct this defendant is all about remedial discretion, and that is all outside the scope of this appeal. So you do have to be careful not to import any concerns you have that would find expression when exercising that Section 37 discretion into the forum inquiry. It's simply the case of, does this court have jurisdiction? That is laser-focused, and that is a relatively self-contained inquiry. And it starts and ends, and I'll foreshadow now what I'm going to say on forum, it starts and ends with the defendant who is challenging jurisdiction identifying an available comparative forum. That's their job. That's what Huawei, or Unwired Planet Huawei, in the Supreme Court says. Paragraph 96. It is incumbent upon any challenger to the jurisdiction to identify an available forum with requisite jurisdiction.
At what stage of the... I mean, isn't it your job to show you can get through the gateway?
Well, this is assuming gateway, and now we're looking at proper forum.
Oh, I see.
And yes, the burden rests on the claimant and stays on the claimant to show that England is the proper forum, but the claimant meets that burden and discharges it unless the challenger, the defendant, at the very least and at the very first hurdle, identifies an available comparator forum, because that's when you get into the Spiliada comparison. Now, there's only two candidates that have been identified here.
But it can't be the case that if the English court exercises certain powers that no other court does, that England is always the proper forum for the claim, just because we have those powers, or do you say that is the consequence?
On the modern interpretation of Spiliada, according to this court in Unwired Planet, and I believe Lord Reid and Lord Sales were part of that panel, it is clear beyond doubt that the challenger will fail at the first hurdle if they do not identify a comparator forum, an available forum with requisite jurisdiction, however the claim is characterised. Now, we say this is an anti-suit claim, a claim to stop unlawful proceedings. My learned friend says it's a breach of contract claim, a claim about breach of an arbitration agreement. Even if you were to accept his characterisation, the French court could never look at that. There are no circumstances in which the French court will ever have jurisdiction, either original jurisdiction or supervisory jurisdiction, to entertain and determine that dispute, however you characterise it. So French court goes. The only one left is arbitration in France. Now, it's rather surreal to find ourselves in a Spiliada analysis comparing the English court with arbitration, precisely because the mechanism for resolving that problem is Section 9, and this is where Section 9 comes in. There is no situation prior to this case in which the Spiliada test has been conducted by comparing the English court with arbitration, either arbitration here or arbitration abroad, potential future arbitration or whatever. And that's because under the scheme of the New York Convention, the English court must stay its action. If it is the case that this anti-suit claim or this breach of contract claim, however you want to characterise it, belongs in arbitration, then my learned friends have to bring a Section 9 stay. They can't just say to you, it can go to arbitration. They have to say to you, it must go to arbitration.
What must go to arbitration?
This claim.
You mean UniCredit's claim for an anti-suit injunction?
Yes. The whole claim, they can't say that it can go to arbitration without saying that it must go to arbitration, because there either is an obligation to arbitrate this anti-suit claim or there isn't. And the bottom line is, and the practical position is, they've waived the ability to say that. So if they've waived their Section 9 rights and they can't say it must go, nor can they say it can go. And therefore, the paradox in their case is what disables them from identifying any comparator forum. The French court is out because it could never have jurisdiction over this claim, and French arbitration is out because they can't be heard to say it, because they've waived their Section 9 rights. Now, the Court of Appeal went the extra mile and compared the English court to French arbitration, just to test the point, and it came up with a whole bunch of reasons in paragraphs 76 to 78 as to why arbitration won't work, and that's going to be the focus of our discussion tomorrow morning and was the focus of the discussion before lunch. But RCA adopts an utterly surreal position on that. They say we should have to go to arbitration, which is going to take 2 to 3 years to get an award, during which time they will have got their monetary judgment in Russia, executed it against my client's assets in Russia, game over. Why should we have to wait 2 to 3 years with jurisdiction fights in arbitration and the potential of it being injuncted by the Russian court for a completely Pyrrhic victory? It doesn't make any sense. So there is an air of surreality around the whole forum analysis presented by my learned friends, and that indeed is the paradox, what we described as the self-inflicted paradox in their case. They cannot aver arbitration rights or be seen to, because their whole position is that there are no arbitration rights. That's why they ran off to the Russian court and seized jurisdiction on the basis there's no arbitration rights. And in the Commerzbank arbitration, which is pending in Paris as we speak, that's exactly what they are saying. Allen and Overy wrote to my instructing solicitors on Monday of this week and shared, because it's not covered by confidentiality under French curial law, shared with us the answer to the request for arbitration from RCA, in which they dispute arbitral jurisdiction on the basis that there are no enforceable arbitration rights. And they also go on to say any award in that arbitration would be unenforceable in Russia, because it's contrary to Russian public policy. So this is the paradox. This is the hair shirt, as it were, that my learned friend has stitched for himself, or his client has, because they are desperate to avoid any appearance of saying arbitration exists or works or is enforceable, but they are asking this court to decline jurisdiction on an all-or-nothing basis so that they are free to continue their unlawful pursuit of those proceedings in Russia. And that is what Lord Justice Mayles described as an abuse of process. That's the abuse. The abuse is being able to use this court's oxygen to advance a case about the availability of arbitration, which is the opposite of what they say. They have renounced arbitration, they have waived Section 9, they have waived their arbitration rights, and they cannot be heard to say that substantial justice is available, or indeed that the jurisdiction is available in France through arbitration. It just doesn't lie in their mouth. Now, I don't rely on that as any kind of shutout. I do say it's unconscionable for a party to come before this court and adopt such inconsistent positions, and for unconscionable, read abusive. But at the very least, it is deeply incredible. It lacks any credibility for them to say this can all be done in arbitration, when they are the deniers and the disavowers of arbitration.
Well, I can see that that might be a merits point, but does it go to jurisdiction?
It does, because it disables them from asserting or averring the availability of arbitration. It's Section 9 or bust. You either say this claim belongs in arbitration, you must stay it, Section 9, or you can't say anything. You can't have it in the middle and just say it could go to arbitration. And that's why we say in our written case, they can't say can without saying must.
But are you then saying that in the gateway, in CPR, there are the two stages? Is the arbitration agreement governed by English law, to which I gather this whole aspect of your argument is not relevant?
No.
No. But then when you get to the proper forum, aspect of the gateway test, are you saying that any defendant who disputes service being served out of the jurisdiction under this gateway is not able to dispute England being the proper forum because they assert that there's an arbitration agreement with a different seat, that they can't do that without getting a Section 9 injunction?
I'm saying when you look at RCA's behaviour in the round, namely its renunciation of arbitration through seizing Russian jurisdiction.
Well, that's a different thing.
In the round, and its disavowal of Section 9, its eschewal of Section 9, what you can take from that is that this defendant has hamstrung itself and disabled itself from saying arbitration is available. And any defendant challenging jurisdiction, you can't identify a comparator forum with requisite jurisdiction fails at first hurdle.
I understand the kind of overall merits argument you're putting forward, but I thought you were making a more specific point that, because you said several times, they waived their Section 9 rights. And I thought you were saying that that means that as far as the proper forum limb of the gateway test is concerned, it's simply not open to them to say the reason why England is not the proper forum is that this should be in arbitration.
I do go as far as to say that, because Huawei in the Supreme Court says if a defendant challenging jurisdiction cannot identify an alternative forum with requisite jurisdiction, then their jurisdiction challenge fails at the first hurdle.
Well, that was on a forum non-convenience,
yes,
wasn't it?
Yes. Absolutely. And the French court is out because the French court could never look at this claim, however you characterise it.
I mean, obviously,
and French...
if you're considering forum non-convenience, if this court has jurisdiction, if England has jurisdiction to decide the dispute and there's no rival jurisdiction which is possibly available, then the forum convenience argument doesn't get off the ground.
Absolutely. I've discharged my burden. Because even though it's my legal burden, the burden within that, the counter burden, is for a defendant challenging jurisdiction to identify a forum, a comparator forum, that is available, jurisdictionally available.
Well, in Huawei, there was absolutely no doubt that England had jurisdiction because it was an English patent which was being infringed, and there was a question as to whether there was a defence because it fell within the regime that governs the global licensing of standard essential patents.
Well, that turned on the characterisation issue. We'll look at Huawei tomorrow morning. I'm conscious that my foreshadowing exercise is becoming my substantive exercise, but sometimes it goes that way. But yes, just in a nutshell, in Huawei there was a characterisation fight over the claim, which the defendant also lost. But then the Supreme Court went on to say, well, actually, irrespective of characterisation, you've lost anyway because the Chinese court just doesn't have jurisdiction under its own rules to even entertain your version of...
Yes, they lost on the forum non-convenience argument.
On the forum convenience argument, yes, absolutely. So that's that. I would just say also that's the abuse of process. The abuse is, in a sense, the procedural abuse of this court's process, or the abuse of this court's process, by seeking to aver the availability of arbitration in France, irrespective of all the practical problems with that, which are second stage analysis, seeking to aver the availability of arbitration in France in circumstances where they don't assert arbitration rights. They do the very opposite. And that's why, of course, they don't say we're in breach, because we've come to the English court to seek remedies for breach of an arbitration agreement, which, on the face of it, prima facie, is arbitrable. So you would have thought the logic of their position would compel them to say, well, you, UniCredit, are in breach of contract. But of course they don't say that. They don't say that because they've waived their arbitration rights over this claim. They've waived any Section 9 ability to get rid of this claim out of the English court.
But at the moment, all we're dealing with is service out of the jurisdiction.
Yes.
But what do you say to their point that you might have jumped on them as having submitted to the jurisdiction if they came and sought us?
We don't say they've submitted to the jurisdiction. We say they've been served out properly, and their challenge to being served out requires them to identify an alternative forum with requisite jurisdiction, and they can't. and therefore their challenge fails at that first hurdle. That's Huawei. And the abuse paradox point shows you why they can't identify French arbitration for that purpose. That's what disables them or disentitles them from saying, bring your anti-suit claim in Paris arbitration. They can't.
I'll be more interested when you come to it in what you say about the French court's position.
Yes, well, that's much more simple. The French court does not have jurisdiction to look at this claim, ever.
Well, the way you characterise the claim.
No, irrespective of characterisation as it happens.
Right.
But the only piece of evidence on that is from Professor Audit, whose report is in the bundle I'm going to show you in due course.
Okay.
And he makes it very clear the fact the parties choose French seats doesn't get them in. They don't have an equivalent in France of our CPR 62.5 1C that allows you to go to French court with French seat. You need more than that. And insofar as there is a jurisdictional competence of the French court, it's for purely supervisory. The French court is even more hands-off than the English court. It's purely supervisory for an arbitration. So it's appointing arbitrators, removing arbitrators, emergency conservatory relief over property, things like that. So the French court could never look at this claim, however you characterise it. No French court will ever possibly entertain a claim for breach of this arbitration agreement. So French courts are out, and French arbitration is out because of the paradox.
You mentioned an evidential reference. Can you just give it again?
Yes, it's Professor Audit. It's paragraphs 19 to 29, and that's core bundle 711 to 713, not contradicted by anybody else. One final opening observation. Oh no, before I finish on that, the abuse of process finding of the Court of Appeal did not feature in the grounds of appeal on ground 2, which is forum. That is something that has crept into my learned friend's written case and was delegated to my learned friend's junior, I suspect, in order to try and show that it doesn't really matter and it's some kind of bolt-on point. It's not. I mean, no disrespect to Mr. Brown like that, but it is not a bolt-on point. It's central and instrumental to why their forum challenge fails. And I'm sorry if that came out the wrong way. I did not mean
Well, I think that, as I understand it, Mr. Brown was invited to speak pursuant to the recent practice direction, specifically...
He was, and he did a fine job of doing that.
Whether he did a fine job or not...
we shouldn't assume that he'd been given only the leftovers of the points that don't matter.
No.
So, because the idea behind that is not to differentiate for the court between good and bad.
No, and just to be clear, I would have said the same thing if Mr. Gunning had done all the submissions and had dealt with abuse last in his submissions. It's not a bolt-on point, it's actually a very central point.
Yeah. I mean, it would cause all sorts of problems if juniors were effectively handed hospital passes.
It would. That might cause me to revisit what I've given Mr. Cribb overnight.
That's not the intention behind the practice.
He may have been given the point that was so easy because there was really nothing in answer to it.
Maybe, but I repeat what I said. If Mr. Gunning had dealt with it last, I'd have made the same point, which is simply it's not a postscript point and it's not a bolt-on point. It's something which Lord Justice Sales deals with at the top of his forum analysis when he introduces it, and then he comes right back in paragraph 78 and says, for all those reasons, it's also abusive. And it's simple logical paradox. You can't have a party denying arbitration and then telling the English court to decline jurisdiction in favour of arbitration. It just doesn't work. There we go. There's one other small paradox which creates a dilemma for my learned friends, and that's this. His whole forum analysis assumes that this claim falls within the phrase in the arbitration agreement of being a dispute arising out of or in connection with the bond. But of course, his whole point on the construction of Clause 11 is that the phrase the bond or this bond doesn't apply to the arbitration agreement. So he has that problem too. That's a mini paradox, if I can put it next to the macro paradox. With that in mind, and it's taken slightly longer than I envisaged, my fault, and I just asked the court to go to section C on page 131 of our written case. This is where we deal, in paragraphs 26 and following, with the practical risks presented by Russian law, and to be more particular, it's the practical risks presented by RCA's engagement of Russian law and use of Russian law. And under 5 separate headings, Russian proceedings, APC 248, imminent adverse judgment, Russian AAI, and unenforceability in Russia, we deal with that cascade of practical risks presented by the Russian procedural law and the Russian process. And I'm going to not go through those. I'm going to assume they are taken as read. And what you will see in the Court of Appeal judgment below, the judgment under appeal, is that they are then reflected in the forum analysis when it comes to looking at whether Paris arbitration is either available or viable. And I noted that my learned friend, if we look at the heading at C4, 133, I noted that my learned friend, for the risk of a Russian AAI, that's an anti-arbitration injunction, said, well, the solution to that is for this court to take some form of limited jurisdiction to grant only an anti-AAI. Well, the answer to that is that presupposes, in my favour, jurisdiction exists, because there's no such thing as splitting jurisdiction. There's either jurisdiction in personam over an injunction claim or there isn't. And it falls on the wrong side of the line in terms of what's out of the scope of appeal, the scope of this appeal, because that's just to do with exercise of equitable remedial discretion. So those risks are compounded risks. My client has assets in Russia, and a judgment is, we would say, imminent. And the reason it's imminent is that this claim was started in August of last year. The Russian court has an assigned judge, Judge Saltykova. She has had the matter back before her, I think, on 4 or 5 instances, running in parallel with this anti-suit litigation. She has all the materials she needs in order to make a judgment on what is effectively 7 on-demand bonds. There's 3, I think, performance bonds and 4 advance payment bonds. They're governed by English law, and as we all know as English commercial lawyers, on-demand bonds are as good as cash in English law. There's one defence effectively to that, and it's EU sanctions, and the Russian court has taken jurisdiction on the basis that it doesn't recognise EU sanctions. So there isn't an awful lot left for Judge Saltykova to do to enter that judgment of almost €500 million. My client has, as I say, executable assets in that jurisdiction. My learned friend forensically complained or observed today for the first time in these proceedings, but Mr. Claypool in his evidence doesn't tell us how many assets or where they are. Well, what bank in my client's position would disclose all of its assets unnecessarily to a client, to an opposition like RCA, given what it's up to? This court can take it that my client is sufficiently concerned about an imminent judgment of €500 million being executed against its assets in Russia to have invested in this anti-suit litigation to bring it to an end. That's the Russian risk. That is all relevant to forum when we get to it, if indeed it is admissible and permissible to compare the English court to a putative Paris arbitration in the first place. If it is, then the answer is to do with risk, risk, risk. Section D starts on 135, and this sets out what is largely common ground about French law, and that runs from 135 to 137. I won't be going back into the evidence on that, but I would like to draw the court's attention to paragraphs 47 and 50, which featured in the discussion pre-lunch, and for the court to note, which is dealt with elsewhere in this written case, it's covered in paragraph 43, that the Court of Appeal asked RCA's leading counsel, my learned friend's predecessor, well, would you give an undertaking to the English court to abide by a Paris tribunal order? Answer, no. And that tells you what you need to know as well. As to the inefficacy or the lack of any real practical value of pursuing arbitration in Paris just to get your hands on something called a tribunal order. Dalico, we have the relevant part of Dalico set out in paragraph 52, which is at the top of 136. And this is the very important nub, as it were, of the Dalico principles. They are replicated in the Dalla judgment at paragraph 14, and that's, I'll just give you the reference, that's bundle page 1278, and also Kebabji, paragraph 88, and that's authorities bundle reference 1725. And what you see from that is what is described as a monist approach. In other words, a French court, whenever seized of an arbitral matter, so irrespective of seat or anything like that, whenever it's seized of an arbitral matter, will simply apply these rules of international arbitration law to determine whether the arbitration agreement was made, who it binds, whether it's enforceable, what it means, and what falls within it, etc. In other words, to supply the answer. You can call that French law. I don't have a problem calling the Dalico principles French law. They are French lex fori. But what they don't do is apply French law, because it is a nonsense to say that French law applies French law. The French courts apply these principles, and you can call these principles French law.
I'm having difficulty gripping this distinction. I think what you just said was that if it came before a French court and the French court had to decide whether this arbitration agreement was valid or whether it covered a particular kind of dispute, they have a set of rules that they apply to decide that.
They do.
And those might be different from the rules that an English court or a Scottish court might apply if it was looking at the question, does this arbitration agreement cover this dispute? Am I right saying?
It is, but the critical difference for our purposes is that an English court or a Scots court or a Swedish court would do a two-stage process. It would use its private international law rules to identify the governing law, and then it would apply that governing law, whether or not it was its own domestic law, to answer those substantive questions. So that's what we describe as a transitive, as it were, a transitive model. English conflicts is a transitive model. We have a set of meta rules which decide which private law you apply, and then the court will apply those rules. The French system is not. It's monist. It's you literally, every French court that is called to look at an international arbitration context simply searches for the common will of the parties. It applies these transnational, delocalized principles of looking for party autonomy and party consent. And that matters here. I'm jumping ahead ever so slightly because I'm moving to ENCA next. That matters here because in our situation, these parties in a 12-clause contract have chosen English law to govern their contract. And what RCA want you to find is that actually, notwithstanding that express choice, they impliedly chose a different type or set of principles to govern the arbitration agreement alone. So having chosen a national system of private law, English law, they nevertheless also chose something which is not a national system of private law, but which is these delocalized transnational principles that the French courts apply. And that, in a sense, is the nub of the ENCA point,
so they
the gateway.
jump over the stage of deciding whose rules will apply.
I'm sorry, my lady.
So they jump over the first stage of deciding.
They do. Well, they gloss what Dalico is about, is what they do, in a desperate attempt to fit it onto or model it onto the Scottish Act, the Swedish Act, and indeed the ENCA exception. We're going to look at that in a moment. The ENCA exception is very clear. It says there has to be a provision in the law of the seat that says where that country's curial law applies to the arbitration process, it will also treat, that law will also treat the arbitration agreement as governed by the law of the seat. So that's what we mean when we talk about transitive. There has to be a provision in the law of the seat which treats the arbitration agreement as governed by its law. It has to do something. Dalico doesn't do that. All that Dalico does is it says, well, what did the parties intend? It's a single inquiry. It's private international law. It's not even curial law in the sense it's got nothing to do with an arbitral process because there may be no arbitration in France at all. And we make those points good in 53 and 54.
In 52, you quote what seems to be the important paragraph.
Yes.
in Dalico, and we see that at the end there's a proviso, unless the parties expressly submitted the validity and effects of the arbitration clause to a particular legal system. So put that to one side. Where if we're not in that scenario, then existence and efficacy are to be considered according to the common will of the parties, without it being necessary to refer to a state law. So do we just dispense with the idea of a governing law?
Yes, altogether.
And ask, I mean, it seems it's so unfamiliar, it's sort of difficult to get one's head around. But, so if they were trying to ask, for example, what is the effect of the EU sanctions directive upon the parties' obligations under the performance bond, you don't answer that question according to English law, French law, or any other law. You ask, what do we think was the common will of the parties?
Well, I'm not sure about that, because I think that would be part of the substantive dispute. That would be about whether there is liability to pay on the bonds, and the question is, what's the impact of a sanctions instrument on that substantive liability? What a French court would ask in any situation where this comes up, so nothing to do with French seat or French arbitration at all, is simply, if one side says, I'm not bound by this arbitration agreement, or it was never signed, or there was no valid assignment to me, or whatever it may be, all the French court would and could do was simply inquire singularly into the will of the parties. What is the common will of the parties? It would look at the evidence, and it would ascertain the common will of the parties, and it would decide if those two parties had agreed an arbitration agreement. That's what French Lex 4 is. It is radically different from the thing contemplated in the chosen seat exception in ENCA, which we'll look at.
If we try and think of an example that doesn't raise sort of public policy issues, suppose one side disputed the binding nature of the arbitration agreement on the grounds that there'd been no consideration for it, just suppose, right? Now, a requirement of consideration is a requirement of English law. So if English law is the governing law of the arbitration agreement, it might well not be binding if there was no consideration. Let's suppose that in French law there's no requirement for consideration, so as long as they both signed up for it, it would be binding. Now, I think what you're saying is that if the French got seized of this, assuming there's no express choice of English law to govern the arbitration agreement, they would apply their set of rules, and let's assume those don't require there to be any consideration, and they would say, well, then it's entirely valid. Whereas if they were looking at, whereas we might say, if it came here, let's look at the proper law of the arbitration agreement, that we would say is French law, and so we don't apply our English concepts of consideration because those have nothing to do with this, and so it's perfectly valid. So is that the kind of thing?
That is possible, save insofar as any references in there to French law, I think, would be excluded. So they would ignore what French domestic private law, i.e. contract law, says about these things.
All right, but suppose one of their transnational principles was that consideration is not needed. Then they would just apply that without first asking whether there is a...
what's the applicable law?
Assuming there's no express choice, and that this is the exercise they would do, regardless of whether the arbitration seat was France or Prague or Vilnius. Or
any international arbitration context, which just means parties who are not French. Yeah, absolutely. It's a single inquiry. It's literally, if you're before the French court and there's any issue as to existence, validity, scope, or effect of an arbitration agreement, it just looks at the common will and gives you the answer. And that is fundamentally different from...
The way they look at the common will is a French way of looking at it, or is governed by sort of French rules.
I'm sure a French judge would say it's an instant...
We're all trying to find what the intention of the parties is, but it's not easy. That's why we're all sitting here. But you then say that those rules that they apply about whether it's valid despite lack of consideration, those rules do not fall into the bucket called French law.
Well, you can descriptively call them French law in the sense that they are principles applied by French courts. That's what the court says in Dalla and in Kebabji. So it would be wrong not to call that French law as a matter of description.
The French court doesn't portray itself as applying French law. It sees itself as applying a transnational body of law.
It does.
Which, as I say, looks suspiciously like French law, but as far as they're concerned, it's an international.
Nobody else
it's an international law.
apart from French.
It is fine in the sense that it's descriptively valid to call the Dalico principles French law because they are principles applied by French courts. But the fact that that description exists and has been said to exist by the Supreme Court twice in Dalla and Kebabji is anodyne in our context, because in our context what you're looking at is an English private international law inquiry as to choice. And I'll come on to this in a moment, where the parties have chosen a single national private law to govern their bargain, in this case English law. A court is only going to find that they chose another law to govern their separable bargain, the arbitration agreement, if that's an equivalent law. It is inherently unlikely that parties having chosen English law, well, I would say it's inherently unlikely that they would choose any other law for their arbitration agreement, but it's technically possible. But it's deeply unlikely and contrary to commercial common sense that they would choose something other than a national system of private law to govern their arbitration agreement in circumstances where they've gone out of their way to choose a single national system of private law, English law, to govern their contract. It would be all of the uncertainties and complexities and absurdities that the ENCA rationale, all 5 judgments in ENCA, went out of their way to discourage. It's not what rational business people desire. They desire certainty, coherence, and simplicity. They want to avoid disputes. They want to avoid dépassage, where they have different terms in their agreement governed by different systems of law. But dépassage, where you have terms governed by different systems of national private law, is one thing. Dépassage, where you have different parts of the same contract governed by a national system of private law on the one hand, and a set of delocalized transnational principles which inquire into the common will of the parties on the other hand, is a recipe for uncertainty and incoherence. And you have to step back. The whole ENCA gateway inquiry here requires you just to step back and say, these parties, in a 12-clause contract where they chose English law in the widest possible terms to apply, did they really also intend at the same time to choose something which isn't even French contract law to govern their arbitration agreement? Because if they'd actually said, we choose French law, that would actually be a choice of French domestic private law. That wouldn't be a choice of Dalico. If someone says, I choose French law for my contract, they're choosing French domestic private law. So it doesn't even work as choice. Now, that probably really ought to bring me on to the gateway, which I'll attempt to finish today. So for these...
So you're saying that the French transnational principles are not the kind of law you choose, they're just what you get if you turn up in Paris.
Absolutely.
And the court is in front of the French court.
Absolutely, whether or not you chose French seat, and that's crucial. And they are not a permissible object of choice in circumstances where parties have chosen a single system of national private law, English law, for their contract.
And presumably the transnational principles of arbitration law are very open to argument as to what they are and what sources one uses and so on. So I suppose it might be said that if you were choosing that, you really are choosing quite a lot of uncertainty
you would
argument and debate.
Yeah, you would be. You could do that expressly, probably. I've had this debate with my fellow pilgrims behind me over whether, well, if you were to choose Dalico, what form of words would you actually choose? But you will never find that in any contract that comes before you of parties having expressly chosen these Dalico principles. They just, because it's not really the valid object or subject of a choice. When parties choose a governing law, they say English law. We've all seen reinsurance slips in our time that just literally say English law. Sometimes it says UK law or whatever. But that's because commercial parties want certainty, and there's nothing more certain than choosing a single system of national private law to govern your contracts. You're literally choosing chitty when you choose English law.
So what does, you say this is how a French court conducts itself, but how does a French arbitral tribunal conduct itself? If there is a choice of English law in the main contract, and the arbitration agreement has the seat in Paris and says, and French law applies to the arbitration agreement, what system of law does the...
Well, perhaps you should postulate when it doesn't say French law applies to the
I'm
arbitration.
asking when it does.
Oh, when it does.
When it does.
If the parties in their contract have said, if the parties in their contract have said French law applies to the arbitration agreement, then under the Dalico principles, French national or domestic private law will apply to the arbitration agreement. Dalico yields to an express choice. But the difference between Dalico and ENCA, if I can put it like that, is Dalico only yields to an explicit choice that makes it very clear that the arbitration agreement is governed by it doesn't have to be French, any system of national private law, whereas ENCA doesn't require that. ENCA raises an inference, depending on the strength of the words in the choice of law, it raises an inference of variable strength, which is then capable, in theory, of being rebutted or negated by a counter choice. And that's the whole point of the ENCA inquiry we're about to turn to. It's all about whether the court can find a counter choice. And the point I'm making, which I think is fundamental to the disposal of this appeal on Gateway, is that the Dalico principles aren't a valid form of counter choice. It's almost impossible to conceive of how you would expressly choose them. Because like I say, if you said French law, you're going to get French domestic municipal private law. You can get the French chitty, if I can put it like that, le chitty. So if it's not readily articulated or capable of being articulated as a choice, an articulated choice, you have to ask yourselves, well, what were the chances that these parties impliedly chose it? Because your search is for an actual implied intention.
Yes, it can't be a choice of law, if you like, because it isn't a law.
Well, yes. that's a better way of putting what I'm trying to say.
I see, but this approach of the French courts, that they will always apply these transnational principles, that's not mirrored by, or is that mirrored by French arbitrators in the Paris seat, that they will also always apply those transnational principles?
That I don't know and can't say. I mean, my own experience of international arbitration is when it comes to the system of law that arbitrators apply, it's a little bit more fluid than that. But if it went on some form of curial challenge to the French court, an award went on the challenge, then you might find, well, the French court would have to apply Dalico, because that's what it does. It's a mandatory lex fori in the country of France.
I can't remember what the tribunal did in Kebabji. They must have...
Well, they split. They were unanimous, 3-0 on applying Dalico rather than English law. Yeah. And they split 2-1, as my learned friend says, of Mr. Reichardt, I think it was, dissenting on whether KFG was bound by that arbitration agreement. So Kebabji is all about whether or not KFG, who came in and bought another company...
Yes, I know, but I was trying to remember what system the arbitrators applied, and you were saying they applied Dalico, even though they're not a court.
Yes, they did. I believe so. Right, so, Gateway.
Do we know whether there are... I mean, is France unique in this respect?
It will say it is, no doubt. But I believe it is, yes.
Right.
And you can glean that almost from the Law Commission's final consultation paper where they surveyed jurisdiction.
Might it be a way in which you will be putting the case that the ENCA principles assume a conflicts of law approach?
Absolutely, yes.
And it just cannot be used when you've got an outlier that is not actually using the conflicts of law approach.
Absolutely. And the best evidence of that, if I can put it like that, is that paragraph 170, small Roman 6, small a, in ENCA, is a summary of 3 paragraphs, paragraphs 69 to 72 or 71, where the only provisions discussed were the Swedish and the Scottish provisions, which are classical or classic choice of law mechanisms.
Yeah, but then the arguments about what the underlying rationale is and whether that extends or it doesn't. I mean, the mere fact that the French system wasn't mentioned doesn't answer the question.
Yes. And then we get to the dog that didn't bark. But there we are. So,
perhaps just to point out that in the expression
It wasn't a dog in Anchor.
Daleco principle in paragraph 52, I mean, the principle itself counterposes the common will of the parties to state law. I mean, you've emphasised that. But
yes.
It's inherent in the statement of Daleco that it's not state law.
Yes. So, applicable law. This is dealt with in the Court of Appeal's judgment in paragraphs 42 to 70. We don't need to look at it now. We say there's no error of law in the Court of Appeal's approach at all. I think my learned friend says that at some point that we disown or don't seek to defend what Lord Justice Males said. That is simply incorrect. And you can see for yourself what Daleco says. Lord Justice Males concluded that the Daleco principles came nowhere near to the sort of contraindication or contra-choice that would be required pursuant to ENCA to dislodge the express choice of English law in this case. And we say he was obviously correct to reach that decision, and his decision is not contaminated by any ascertainable error of law at all. It's simply a rerun in this court, and in fact a rerun which in large part sounded and felt an awful lot like a criticism of the outcome in ENCA itself. Not the literal outcome, but the sequence and the hierarchy within 170, which I think my Lord Sales picked up on at one point. Now, it's vital to bear in mind, I foreshadowed some of this, and I will finish applicable law today, that this is about a search. What the English court is doing is it is searching or conducting an inquiry to search for an actual implied choice, not a deemed choice, not an imputed choice. English conflicts has moved a long way from the days of deemed choices and imputed choices. It's not what we do anymore.
Well, when you say an actual choice, you mean though objectively determined still. So to that extent, it's not.
It is, but
looking at what parties have subjectively chosen. So there's an element of presumption. But it's a matter of interpretation.
It is. It's a unitary exercise, and it's an easy one in this case because there's 12 clauses. I mean, sometimes these contracts are volumes deep, aren't they? But you have 12 clauses here in what may well just be machine-generated, if I can put it like that, performance bonds or advance payment bonds. They certainly come up in that sort of telex style, don't they? That automated style. And we'll go through one of them in due course. And it's only 12 clauses long, and Clause 11, the one that comes before the arbitration agreement, says this bond and everything else is all governed by English law. And Clause 12...
It may makes a difference whether it's 2 clauses or 29, does it?
It's a unitary exercise, it's just that some are easier than others, if I can put it like that. And this unitary exercise is open and shut in my submission, as Lord Justice Males found. Because in a 12-clause contract, where there's a simple choice of English law, it's going to take an awful lot by way of counter-indication or contra-indication to say that the parties chose something other than English law to govern those 2 of those 3 sentences which constitute the arbitration agreement in Clause 12. So it's very important to remember it's a search for an actual implied choice, not some form of imputed choice, which involves a number of stages with deemed awareness of French court principles and things like that. You've got to be realistic about this. You also are looking for, as a matter of English private international law, you are looking for a system of national private law. That's the object of the inquiry, and we get that from ENCA, paragraph 2, which we've quoted, I suspect, more than once in our written case. That is at page 1404. The central issue on this appeal concerns which system of national law governs the validity and scope of the arbitration agreement when the law applicable to the contract containing it differs from the law of the seat of the arbitration. And what we've given you in paragraph 132, we don't have to turn it up now, 132 of our written case, is authority of the highest level to show that it is not just a tradition but a requirement of English private international law that contracts are governed by systems of national private law. It's theoretically possible, because dépassage is permitted even though discouraged, to have a contract governed by different parts of a contract, I should say, governed by different systems of national private law. But there is no prior case that has found that a contract is governed as to most or all of its clauses by a system of national private law, but as to one clause only by something which doesn't constitute national private law, and that would be this case, and that's why we say it's inherently unlikely. The Law Commission itself, in its final consultation paper, said in terms, contracts are governed by contract law. And the whole point of Section 6A, effectively changing the law from ENCA, is to decide which contract law, which country's contract law governs. Now that's all set out in paragraph 132 of our written case, and Dicey 32-075 and following, which is cited there and referenced there, shows you that English private international law is looking for a system of national private law to govern a contract. Simple. Now that choice has to be real and clear. And we know that not just from English common law conflicts of laws, but also because the parallel regimes in the Rome Convention and the Rome I regulation also make it clear that choice has to be a real choice and has to be clearly demonstrated. So then you have to stand back and ask yourselves, well, did these parties here clearly demonstrate a choice, a real choice, to have their arbitration agreement in the last two sentences of Clause 12 governed by something other than English law? And the answer, we say, as the Court of Appeal said, is obviously no. There's no clear choice to that effect. How likely is it that, having gone out of their way to choose English law, they nevertheless impliedly chose something which isn't even French contract law to govern that arbitration agreement? Answer, not very. Now, that is a unitary exercise, sometimes described as an iterative exercise, where you have to look at all 12 clauses together in order to construe that choice of law.
But I thought you said there that they haven't chosen French contract law, but I thought earlier you were saying what you have to choose is a choice of law by the seat.
Well,
whether you call these transnational principles French contract law or not seems to be a question of semantics. They are the rules that they will apply to determine what the terms of the agreement are.
no.
They are French contract law to that extent, but I thought that you were not accepting that that was what you're looking for. I thought you were saying that there's a sort of pre-step that there has to be some choice by the
Yes.
national...
No. Well, we're talking about two different things. English private international law requires a contract to be governed by usually one, but it's possible to be more than one, system of national private law. And therefore, if you've made an express choice of one, English law, it's highly unlikely, and in fact I would say impossible or inadmissible, to actually choose something which isn't such a system of law. Point one. The ENCA exception in 170 Roman 6 small a requires the provision in the law of the seat to be a choice of law mechanism that will result in the application of a governing law, which is also, by definition, a system of national private law. Now, that implied choice, that counter choice as we're calling it, would have to be akin to an implied term. We've given you the reference to what Lord Justice Mance said in the Cellstar case. This is all in the written case. But how likely is it you're going to have an implied term that the arbitration agreement is governed by something which isn't French law, but which is the transnational principles we're calling Dalico, in circumstances where the parties haven't made that very clear express choice just two sentences earlier for English law? If you run it like an English implied term analysis, you can see just how fraught that is, because the choice is inconsistent with the express terms. The best, you can't rely on the doctrine of separability to give you this answer, because that has been very much downgraded, if I can put it like that, or put back in its box by the ENCA judgments. That's paragraph 62, 240 and 269 for all three judgments in ENCA. Separability, as we now all know, is really about the independent or autonomous lifespan of the arbitration agreement. It is not about some form of juridical identity which readily justifies it being governed by a different system of law. It makes it technically possible, but it doesn't justify it. And indeed, Lord Sales in Enker at paragraph 269, and indeed the majority at paragraph 62, went out of their way to say that a contract creates a unified package of rights. And the arbitration clause, which is juridically a separable agreement, is simply part of a unified package of rights. And therefore, all things being equal, the parties are going to be expected to have wanted that unified package of rights to be governed by a single governing law. Nor does the choice of seat and therefore or thereby the choice of curial law have anything really to say on this. This is all dealt with in Enker, because choice of curial law by dint of choice of seat is simply choosing the procedural law that applies to your actual arbitration process and its outcome, i.e. curial challenges to any award. And as we say in our written case, you can actually take that further, and when you properly analyse it, curial law applies to a different contract altogether. Curial law doesn't have any application whatsoever to the arbitration agreement. If the parties start an arbitration, they create a new contract, which we call the reference to arbitration. That reference to arbitration is in the nature of an umbrella contract with many, many parties to it. There is a separate private mandate, as it were, between each arbitrator and each party. It creates a reference to arbitration in France, creates a French reference to arbitration, which when you break it down contains a multitude of different private relationships between each arbitrator, between themselves, between each one and the parties. That's what curial law applies to, the process of arbitration and those relationships flowing from an arbitration. And the judgments in Enker...
Is that a way that it's been analysed before? That in a sense one's got a separate contractual relationship?
Yeah, Mr. Justice Mustel, as he was in a case called Black Clawson, if not what he said in the House of Lords in Channel Tunnel, was quite clear to say, well, the one that's often overlooked is the fourth contract in all of this. You have the law governing the main contract, you have the curial law governing arbitral procedure, and then you have this thing called the law governing the arbitration agreement, but there's also a separate reference. That reference to arbitration creates, like I say, a web of contractual relationships between arbitrators, between each of them and the parties, and the curial law governs the process, but the law that governs that separate reference is something else completely. So the idea that choosing seat and therefore choosing curial law has anything to say about the party's choice of the law to govern their initial single promise to arbitrate is a very curious one indeed, and the logic of Enker and various statements in the Enker judgments make that clear. But what they don't do, because they didn't need to do, is analyse it through to those separate and distinct contracts.
Do we have Black Clawson in the bundle?
We don't know. No, I don't think you need it, because I would rest on what is said in Enker about that. And in a sense, I'm not here to defend Enker, although there were times this morning when I felt as though that was becoming my job. But of course, this is not about an attack on Enker. So what my learned friend is left with is simply having to try and construct some form of implied actual choice from the simple fact that seats has been chosen. But of course, that is a whole chain of choices. You choose seats, you choose curial law for the process of arbitration, you choose curial jurisdiction to police the arbitration, you look into the code of state regulation of arbitration, let's just call that arbitration law. Some of that is curial law, some of that is something else. You find a provision in that code that tells you which law applies, and then stage 5 or stage 6 you say, aha, therefore the parties can be taken. This is the therefore in our written case. Therefore the parties can be taken to have actually chosen the law of the seat, but only if they've been taken to have chosen the domestic private contract law of the seat. That's the whole point of Enker. So let's look at that provision now. Paragraph 170.
But if these transnational principles had been enacted in a French statute that said French International Arbitration Law Act, and it had set those out as applicable in every French court in the if a French court was dealing with an international arbitration as defined, would you still say that that's not French domestic law?
I would say that still isn't a type of law that is an admissible object of inquiry under ENCA. Because where the parties have chosen English law, then you're not going to be able to find that they nevertheless chose a different system of law to govern their arbitration agreement, because it's not an equivalent system, as it were. But we're not in that territory, because Delico is all judge-made. And also, let's not lose sight of the fact that this is all part of a unitary process of interpretation. And this is very important when we come on to Karpatsky case. And my learned friend makes a lot of that first instance judgment of Mr. Justice Butcher in Karpatsky. But in Karpatsky, there was a very weak choice of law. It was the choice of law was the substantive law of Ukraine to govern disputes. So actually, one rationalization of the Karpatsky decision is, well, it was a very weak choice of Ukrainian law in the first place, which was very easily rebutted. Of course, that's the opposite in our situation here. We have a very strong choice of English law in Clause 11, which is expansive, if I can put it like that. And therefore, it's going to require, the stronger the choice of English law, the stronger the choice, the counter-choice has to be, by definition. So we're nowhere near Karpatsky, just on the contract. And that's vital. And when you come to look at paragraph 170 of ENCA, so this bundle, Authorities Bundle 1460, the first point to note, and this is obvious, is that what follows in those 9 Roman numerals has to reflect what's gone before. There's 169 paragraphs worth of analysis which has preceded this, and you can indeed, when you do the job, cross-reference this and find the place in the preceding analysis where every single one of these propositions comes from. The 9 sub-propositions, or 9 propositions, break down into 3 parts of 3 propositions. Roman 1 to Roman 3 are a summary of English private international law, a thing we call English conflicts. And that is summarizing what an English court is doing when it's approaching this exercise, and it's becoming, or putting on its English contract lawyer hat in order to understand what the parties chose, if indeed they chose anything. So that's 1 to 3. 4 to 6 is then telling you what the primary rule is. The primary rule where a choice of governing law for the contract has been made. That's the second line of Roman 4. The primary rule where a choice is made in the contract is that will generally apply to the arbitration agreement. That flows from the unified package of rights that we see in all 3 of the judgments. Roman 5, and we discussed some of this morning, or the court did with my learned friend, says, well, choice of seats not enough. And that's because of the primacy of choice of law. Choice of seats not enough to rebut it. And then Roman 6 has 2 potential negating or rebuttal factors. A, the one we're concerned with, and then we'll come back to, and B, the so-called validation principle. And then there's the sentence at the end, E, the factor may be reinforced by circumstances indicating the seat was deliberately chosen as a neutral forum. Now, something worth emphasising, which Lord Justice Mayles did in paragraph, I think, 57 of the judgment below, is just how hedged or tentative Roman 6 is, because he put in italics all 3 instances where the court uses the word may. Additional factors which may, however, negate such an inference, and may in some cases imply, that the arbitration agreement was intended to be governed by the law of the seat are, and then that sentence at the end about neutrality, either factor may be reinforced. So what that is saying is this is all part of that unitary exercise. You look at all the clauses in the contract, you construe the choice of law in its context and within its contractual scheme or home, as it were. And it may well be that a choice is so clear that neither A or B could work, but B, the validation principle, is the one that's more likely to work because of the principles discussed in ENCA, namely, well, how likely is it that the parties have chosen a law which actually strikes down the very thing they're trying to achieve? But A, which is the choice of seat exception, the so-called curial law carve-out, we have to be very careful about what it says. It says any provision of the law of the seat which indicates that where an arbitration is subject to that law, so pause there, so there's a provision in the seat which says if our curial law applies, in other words, if we are the chosen seat, and then reading on, the arbitration agreement will also be treated as governed by that country's law. So it's very, very narrow, and indeed it is based on the Swedish and the Scottish model that you see discussed in paragraphs 69 to 72. You have to have a provision that says, because we are the law of the seat, and because our curial law applies to the arbitral process here, therefore also, key word also, the arbitration agreement will be treated as governed by. Now, that is just not what Dalico does. Dalico doesn't treat anything. The French Lex Fori doesn't treat anything. It doesn't apply anything. It doesn't treat anything. It doesn't do anything. It is not a choice of law model, and that's what's so fundamental here. It simply supplies the answer. And if you go back in ENCA to where this comes from, if I can put it like that, where it has its counterpoint in the substantive analysis, that all starts in a heading for section Roman 5 above paragraph 59, that's authority page 1422. The approach of the Court of Appeal. This is a very important section, and I'll invite the court to reflect on it after the hearing. There isn't enough time to go through it now. This section runs all the way from paragraph 59 to 94. And what it does is it deals with what the Court of Appeal found, because they put choice of seat as the primary rule, and why that is wrong. That's what I referred to earlier as in a sense, the ratio of ENCA. The whole point of ENCA was it elevated choice of law as the primary rule and subordinated choice of seat to the default rule, which happened to follow the scheme of Article 5(1)(a) of the New York Convention as well. But, so you see there, paragraph 60, dealing with separability. Paragraph 62, which I alluded to earlier on page 1423, I basically paraphrased the sentence in about 8 lines down. The arbitration clause is nonetheless part of the bundle of rights and obligations recorded in the contractual document. So, for example, an assignment of the contract will include an arbitration clause without the need for any separate or additional assignment. And we'll come back to that point when we look at the bonds in a short while. They then deal with the overlap argument, paragraph 65 over the page, and then you get the choice of curial law. And paragraph 68 and 69 are important because what they discuss is the whole practical, in a sense, the practical implications of choice of seat. When parties choose arbitral seat, they are making that choice for practical reasons. They are choosing the curial law to govern the process of arbitration, and they are choosing the curial court to regulate arbitration and determine the validity of its outcome, i.e. any awards. That's what you're doing when you're choosing seat. You're doing those practical things, even if it's neutral, or especially if it's neutral. And then you get paragraph 69, which is the bridge into the discussion of Karpatsky. As noted at the beginning of this judgment, the curial law which applies to the arbitration process is conceptually distinct from the law which governs the validity and scope of the arbitration agreement, whether a choice of the curial law carries any implication that the parties intended the same system of law to govern the arbitration agreement, and in these words I would ask you to emphasise, and if so, the strength of any such implication must depend on the content of the relevant curial law. So what paragraph 69 is making clear is that this is all part and parcel of a unitary interpretive inquiry. There are strong choices, express choices of law, and there are weaker express choices of law. And whether there is a feature of the curial law which points you in the direction of another system of private law to govern the arbitration agreement is going to be context specific. And if you start out with a very strong choice, in this case, a very strong choice of English law, it's going to take a very clear contraindicator to show that there was nevertheless a contra-choice or contrary choice of the same law of the seat to govern the arbitration agreement. So those words, and if so, the strength of any such implication, are important. And of course, they have their counterpoint in the use of the word may 3 times in Roman 6, in paragraph 170. And if we then go back, well, I should show you paragraph 94, because that concludes section Roman 5 of the judgment, where there is, in a sense, a repetition of paragraph 69 that we just looked at. While a choice of seat and curial law is capable in some cases, sorry, page 1434. While a choice of seat and curial law is capable in some cases, that's quite theoretical, based on the content of the relevant curial law, supporting an inference that the parties were choosing the law of that place to govern the arbitration agreement. It's quite clear that what you would have to have is a clear implication of an actual choice, that by choosing seat X, you are submitting yourself to the choice of law mechanism in arbitration law X, and therefore actually choosing law X, contract law X, if I can put it like that, to govern your arbitration agreement. And it's all context specific, and it depends about the strength of the choice. And like I say, Dalico is of a completely different order to the only 2 examples that were given to support that, namely the Swedish Act and the Scottish Act. Now, just to conclude 170, the final set of principles, which don't really matter for our purposes, are Roman 7 to 9. They deal with a situation where there's no choice. But that no longer features, I don't think, now in the analysis before this court. It did in the court below. Right, can we therefore go back to Dalico, and I'll tell you, I'll summarise our position on this. But before I do that, I wanted to show you a few references in my learned friend's case, which is where I say the mischaracterisation has crept in. If I can ask you, please, to go to page 82. Or I hope you've got the first page under the heading A, Introduction to my learned friend's written case. Paragraph 4A. The seat of the arbitration is France. This is a summary of their case. The seat of the arbitration is France, and under French law, the arbitration agreements would be governed by French law. That's the first example of a few I'm going to show you where my learned friends have attempted, through some form of linguistic alchemy, to convert Dalico into a choice of law mechanism when it is no such thing. The next one is paragraph 44 on page 98. In fact, it's over the page onto 99. Final sentence, put another way, absent an express choice to the contrary in the arbitration agreement. In France, the law governing the arbitration agreement is always French law. Again, you get this double-barreled French law. That's not the worst offender. The next paragraph is one of the worst offenders, 45, in the middle. As a matter of French law, the agreements to arbitrate in the bonds would be treated as governed by French law. That sentence, I'm afraid to say, with the greatest respect, is nonsense. That is not what Dalico does. Dalico does not treat the arbitration agreement as governed by. My learned friends are trying to shoehorn Dalico into this exception in ENCA by copying the words in the ENCA exception, but it just doesn't work. You see it again in 46A, the fact that French law will apply principles of French law. That's nonsense. Dalico just gives you the answer.
What do you mean gives you the answer? Gives you the answer to what?
The question of whether the arbitration agreement was made, whether it's valid, what it means, and what its effect is. It just gives you the answer. It doesn't apply anything. The French courts applied Dalico, but French law doesn't apply anything. French law just gives you the answer. French lex fori just gives you the answer. And you see it in 49, French law applies French legal principles, and then in 54B, under French law, the arbitration agreements would be governed by French law. And I don't wish to be too rude, but those passages I've shown you, those phrases I've shown you, are just a council's attempt to manipulate the Dalico principles and turn them into something which they are not. You'll have noticed that on every occasion, my learned friends have inserted a verb, either an active verb or a passive verb. They either say French law applies French law, or they say under French law, the agreements would be treated as governed by French law. They have inserted the verbs because they are seeking to turn something which is intransitive into something which is transitive. So, what we say...
So you say that they're trying to shoehorn a non-conflicts of law system into a conflicts of law system?
Yeah, absolutely, yes.
Why does that matter if what it provides is the answer to the questions that people want to know about the validity and scope and operation and meaning of the arbitration agreement? Why does it matter whether they're applied just directly, not wishing to introduce another word, or whether they apply because they first choose French law and that's what French law says?
It matters for two reasons, my lady. Reason number one, English private international law expects and requires a contract to be governed by a system of national private law, what you can colloquially call contract law. I've shown you the references for that and given you the references for that. So that is what you're looking for. That's point one. Point two, and that applies here, where the parties have chosen such a system of domestic or national private law, here English law, then the only way that can be displaced for their arbitration agreement is if they've effectively chosen a substitute system of national private law for their arbitration agreement. And the only way they can do that is if they can point to a provision in the law of the seat which operates as a choice of law provision which supplies that contrary or substitute system of private law, national system of private law. In some ways, they're two facets of the same argument, but one is general as to what English private international law is and does, and the other one is specific as to when you're searching for a choice when there already is an express choice to start with. I feel a question may be coming, my lord, but maybe not.
Well, sorry, I just want to say, I wonder if there's a third point as well, perhaps of a different order, but in both paragraphs 69 and 94 of ENCA, which you showed us, the reference to the curial law and whether that informs the objective choice of the parties was said to depend on the content of the relevant curial law.
Yes.
So even, I wonder whether there's this point as well, that even if the common will of the parties, as distinct from French law, were to be treated as a curial law, it's going to be that much more uncertain than French law in the generality, and whether that features in the analysis.
Yes, and of course, that makes it inherently even less likely that the parties would have swapped out the inherent certainty and coherence of English contract law for something which is the opposite, or certainly...
What's the difference between English contract law and identifying the common will of the parties? Isn't that what English contract law is, in summary, doing? Isn't that what ENCA paragraph 170 is doing. It's giving you a structure to try and find what the common will of the parties is.
Well, all we know is the parties have chosen English law to govern their contract. And in this jurisdiction and its heritage of mercantile law and all the certainties that creates and cherishes for the past 300 years is something worth choosing. And the likelihood that commercial parties, having chosen English law and all that stands for and all that gives them, in return for something which is not of the same quality, is just not likely.
That's the point on how strong the choice of English law is. There's only 12 clauses, but
beyond that, I can't really answer my lady's question, other than that it's inherently deeply unlikely that parties that choose English law would swap out or substitute in something which doesn't even resemble contract law to govern a separate part of their single agreement, their unified package of rights. But I can't answer it beyond that. So what we say, in summary, is that the Dalico principles can't be chosen at all. I'm going to give you the 3 propositions in a row. They start with the strongest and they go down to in a sense, the most specific in our case. The Dalico principles just aren't capable of being chosen at all, pursuant to the ENCA carve-out, because they are not a national system of private law. Full stop. That's the strongest case. The first fallback from that is they're not capable of being chosen as a counter-choice in circumstances where parties have chosen English law to govern their contract, for the reasons we've just been discussing now, my lady. And then the fallback from that, which is all we need, is that even if they are capable, even if Dalico were capable of being chosen in that way and in those circumstances, they weren't here, because the English law choice is so strong here that it would take a very strong rebuttal or counter-choice to dislodge or displace it. And can I, therefore, just go quickly into one of the bonds?
Can you just refer me to the authorities that support or where I find the authorities that support your first proposition?
Yes, paragraph 2 of ENCA, which says the search is for a system of national law.
Right.
What the Law Commission have said, would you like, I can give you a better reference for that. That's authorities tab. Well, you're not working.
I think paragraph 2 of ENCA was setting the general scene. It
Yes.
wasn't considering the subtleties that we're getting into in this case. So,
what the Law Commission said at page 2044 of the Authorities Bundle, paragraph 12.4, contract law guides us in resolving disputes about contracts, like what the contract means or who is a party to it. And then this sentence, where there is an international dimension to the contract, we need to identify which country's contract law will be relevant. And then you have DICE 32-075.
I think these are the authorities set out at paragraph 132 of your...
They are, yes. Yes. I didn't know whether they needed giving again.
no, not if you have the reference in your case. That's
They are.
fine. I get all that.
Yeah, sorry. So if we can look at what's known as bond number 1, this is in core bundle, page 247. As I indicated earlier, there's 7 bonds that form the subject matter of this dispute and the unlawful claim in Russia. 4 of them are performance bonds. That's bonds number 1, 4, 5, and 6. 3 of them are advance payment bonds. That's bonds number 2, 3, and 7. The only difference between them is that some of the numbering jumps around because the one family of bonds has a slightly different set of wording for the other, but the clauses that matter all bear the same numbers. So we can work off bond number 1, which starts at page 247. And to answer or pick up on my learned friend's answer to Lady Rose's question from this morning, the bond, capital B, is not defined. You see on the first page, performance bond number, and I won't read out the number. This one is for 75 million euros. And then
this isn't a translation. The bond is in English.
It is, yes. And indeed, it requires by clause 5, I think, that all documents specified in it must be sent in English. And it is governed by English law. So it starts with this bond, dear sir or madam, this bond, where it's in full capitals, is made on the 3rd of August. You can observe at that point, so is clause 12, by definition. It didn't pre-exist. You then get a series of recitals, which we don't need to worry about. We don't need to pick up on every reference to this bond or the bond. You get the heading operative towards the middle of the next page, and then you have a series of 12 numbered clauses. Interestingly, 4 or 5 lines in clause 1, there's a reference to an Annex 1 to this bond. If you jump ahead ever slightly, and this is only a small point, but it slightly proves the point, page 251, you'll see that Annex 1, form of demand, comes at the end, so it comes after all 12 clauses, as you would expect, suggesting that the bond, or this bond, is indeed all 12 clauses of it. My learned friend relies, or has alluded to, and certainly relied below on clause 6 on page 249. This bond shall come into force at the date of issue, and then it's got provisions for expiring. That is a common occurrence in contracts governed by English law, that they have inception clauses, expiration clauses, termination clauses, as did the contract in Kebabji, where the reference to this agreement, or in this case, this bond, is not referring to the arbitration agreement, because obviously arbitration agreements outlast the termination or expiration of the main stroke host stroke matrix contract. So the fact that it says that in clause 6 doesn't tell you that the phrase this bond has a rigid meaning and never includes clause 12. A clause which is of particular interest when it comes to construing clause 11, which is the entire job that you are doing on Gateway, is clause 9. Clause 9 regulates the ability to assign, charge, transfer rights under this bond. Now, on my learned friend's construction, this bond, that would potentially, or actually, not include the arbitration agreement, in which case these parties would have in fact contracted for uncertainty, not certainty, because there would be a regime regulating the assignment of all the substantive provisions, but not the arbitration agreement, because according to him, this bond, the phrase this bond does not include the arbitration agreement. And then you would end up in a situation which I think I described in the Court of Appeal as the horror scenario, where you might have a disputed assignment, where you have to arbitrate against the original party, the assignor, but litigate against the assignee, because the assignee says, for whatever reason, that the arbitration agreement wasn't assigned to it. You can have a splitting, as it were, of assignor and assignee. The sensible construction of clause 9 is that the phrase its rights and benefits under this bond must include clause 12. And I showed you paragraph 62 of ENCA about half an hour ago, where the majority judgment spoke of the unified package of rights that the arbitration clause forms a part of, and said that it's axiomatic that an assignment of a contract includes the assignment of the arbitration clause within it, because it's stitched into and forms part of that unified package. Now, is my learned friend really going to contend that the phrase under this bond in clause 9 doesn't include the arbitration agreement? Because he's got a bit of difficulty if he is going to say that. And then, of course, you get to clause 11, and we looked at that this morning. This bond and all non-contractual and other obligations arising out of or in connection with it shall be construed under and governed by English law. You can't find a wider choice of law than that. That is two commercial parties going out of their way to indicate a choice of English law to cover everything that could impact their relationship, everything.
That formulation is, I think, wider than in clause 9. In clause 9, it's rights and benefits under this bond.
Oh yes, but it's the use of the phrase under this bond in clause 9 which I think is telling. Because on my learned friend's construction of that phrase, the clause 9 would not apply to the arbitration agreement.
Yes, no,
yeah. But I see
but it was
the nexus.
My point, which is perhaps supportive of your case, that you say clause 9 under rights and benefits under this bond should be taken to include the arbitration agreement.
Yeah.
And what I was just pointing out is that the formula in clause 11 seems to be even wider than that. So
it does indeed. Although in fairness, and maybe that's where I was going, the nexus language in 11 is to do with things which aren't contractual, arguably. And we are happy to run this case, and always have been, on the basis that the phrase "this bond" in clause 11 obviously covers all of clause 12. And just briefly, because I'm conscious that it's 4 o'clock, but this brings to an end my submissions on Gateway. When you look at clause 12, you see that it has 3 sentences. The first sentence isn't part of the arbitration agreement at all. The first sentence is an independent promissory regime that compels the parties, as a matter of English law, because it is obviously governed by English law, to do their best to get rid of any disputes, if I can paraphrase. And that is then a condition precedent, the arbitration agreement that follows, because you can see that from the words in brackets in the 5th line, which cannot be resolved amicably. So one of the curiosities which makes my learned friend's job even harder on the interpretation here is that clause 12 itself is a mixture of an arbitration agreement in the 2nd and 3rd sentences and a separate promise in the 1st sentence, which on any view has to be governed by English law.
Well, I'm not sure whether that's true. Is it? Wasn't there a similar sort of thing in Enker, I seem to remember?
In Enker there was
I mean, there's an argument that if the arbitration agreement is governed by a particular law, then that, as it were, brings within its orbit the run-up to that, if you have to go through some process of good faith discussion first.
There is an argument, but it all depends on context. And in Enker, Article 50.1 of the construction contract, I believe, was headed dispute resolution, and then had a series of things which weren't arbitration, followed by something that was. So the argument that they all form part of a dispute resolution package and ought to be governed by the same law was that much stronger. This doesn't. This is just clause 12 with a separate first sentence, with a separate independent promissory regime, which we say must be governed by English law. And on my learned friend's case, therefore, you would have the further oddity that notwithstanding that very wide choice in clause 11, some of clause 12 was governed by English law, but not all of it. And indeed, the bit that isn't would be subjected to a condition precedent that was governed by English law. So you're just compounding uncertainty, complexity, and incoherence at this point. Now, I have gone 2 minutes past 4 o'clock, and I apologise for that. That concludes, subject to being prodded overnight, as it were, what I was going to say on Gateway.
Very well. Thank you very much, Mr. Houseman. We'll resume tomorrow morning at 10:30, and in the meantime, we'll adjourn.